This is Dr. S. the Legend. I want to talk about birthright citizenship. Birthright citizenship means you're born in the United States and you automatically become a citizen regardless of your parents' situation. And we're talking here about whether someone is a legal or illegal alien. That is the correct legal term. If you're legally in the United States, you're a legal alien. If you're not here legally, you're an illegal alien. You're not a migrant and you're not an undocumented person. Let's get our vocabulary straight. Now, President Trump passed an executive order on January 20th, 2025. It had two basic parts. I'll read it in depth a little bit later. Part number one says that you're not a citizen if you're a child born in the United States of an illegal mother as well as father. Second category applies to children of people that are here temporarily. They're here on a visa, whether it be a student visa, a work visa, or an employment visa, or a student visa. So the Supreme Court is going to hear the appeal, and the appeal comes from the First Circuit Court. First we have a district court, which is the trial court. Then it goes to the circuit court. Now the Supreme Court has agreed to hear the case on birthright citizenship, whether it's legal or not legal. And the fact that they're hearing the case indicates to me that they may very well limit birthright citizenship. They're probably going to hear all oral arguments in the spring of 2026, and they're probably going to rule, since it's going to be a controversial decision, on June 30th, 2026, which is their last day that they're hearing cases and giving opinions. In order to hear a case before the Supreme Court, you have what is known as the Rule of 4, meaning 4 justices of the 9 have to agree to hear the case. It's really the Rule of 5, because you need a majority, and a majority is 5, either 5, 6, 7, 8, or 9. So why are they hearing the case if they're not going to limit birthright citizenship? And by the way, there is no European country that has birthright automatic citizenship. So, continuing. They're going to hear the case because there was a prior case in March of 1898. That was the only case. It's called Wong Kim Ark. I will review the case very briefly. Also relevant is the 14th Amendment. And then they're going to deal with the interpretation of the 14th Amendment. And the 14th Amendment was passed in 1868. And it's my opinion that they're going to say that the Ark Supreme Court case in 1898, as well as the 14th Amendment, do not apply to automatic citizenship by birth. They're going to go through the original meaning of both the Supreme Court case and the 14th Amendment. And they're going to say that it does not apply, these two things do not apply to the children of illegal aliens or those that are here temporarily in the United States. Now let me go through the 14th Amendment, and I'll make this absolutely clear. The 14th Amendment was not passed just by itself. It didn't exist in a vacuum. It was part of the Reconstruction Amendments. The 14th Amendment was passed in 1865. Prior to that, in 1868. Prior to that was the 13th Amendment in 1865 and the 15th Amendment in 1870. I'll briefly go through these. They all were passed together after the Civil War. They all only had to do with those that had been previously enslaved. The 13th Amendment ended slavery, period. The 14th Amendment gave citizenship to the freed men and women, period. And the 15th Amendment gave the right to vote to black males that were no longer slaves. They couldn't give it to the women because women at that time did not vote in the United States. They didn't vote till 1920, till an amendment was passed to the Constitution. So the 14th Amendment only applied to former slaves, not to anyone else, even though other people come up with all kinds of fantastic interpretations. The Supreme Court is going to look to the original meaning both of the 14th Amendment and to the Supreme Court case. When they do this, individuals on the court, they are called Originalists. And today there are 5 members on the Supreme Court, Gorsuch, Kavanaugh, Alito, Thomas, and Barrett, who are Originalists. And Originalist means the original public meaning at the time it was written. They're going to look at the 14th Amendment as it was written at that time, not how people interpret it yesterday or last week. And the important part of the 14th Amendment, which I'll go into very briefly, is the whole issue of a clause in there which is called subject to the jurisdiction thereof. Now let me go through Donald Trump's executive order. And I'm going to read for you Executive Order, January 20th, 2025. Not the whole order, but the important parts. Quoting him, the 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Sanford in 1857, which misinterpreted the Constitution as permanently excluding people of African descent from eligibility for United States citizenship solely based on their race. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born in the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that, quote, a person born in the United States and subject to the jurisdiction thereof, unquote, is a national and citizen of the United States. This is 8 U.S.C. 1401. It mirrors the 14th Amendment. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of United States citizenship does not automatically extend to persons born in the United States. This is the important part. Number 1, when that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. Number 2, when that person's mother's presence in the United States at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the Visa Waiver Program, or visiting on a student, work, or tourist visit, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. And subsection A of this section shall only apply to persons who are born within the United States after 30 days from the date of this order, which was January 20th, 2025. And just briefly again go through the federal statute 8 U.S.C. 1401A. The following shall be nationals and citizens of the United States at birth. A person born in the United States and subject to the jurisdiction thereof. Again, that sentence fragment is very, very important. Subject to the jurisdiction thereof. Supreme Court is going to question the meaning of that sentence fragment, and they're going to apply it to the law. Now let me go through the one Supreme Court case that some people are using to justify birthright citizenship. It's called United States versus Wong Kim Ark. This was decided March 28th, 1898. This was a long time ago, just as the 14th Amendment was a long time ago. Now, Wong Kim Ark was a person, a male person. His parents, at the best that I can determine, were not illegal aliens, were here temporarily. And you have to understand at the time they had a law. And he was of Chinese descent, so was his parents. They had the Chinese Exclusion Act of 1882, and it lasted all the way to 1943. This meant that people could not come from China to the United States, beginning in 1882 all the way through 1943. And I'm not going to argue the propriety of this. It just existed at that time. So Mr. Ark was born in the United States in San Francisco in 1873. That was before the Chinese Exclusion Act. Parents were domiciled residents of the United States. Therefore, they must have come here legally. Now, in 1890, Ark and his parents went back to China, maybe because of the Chinese Exclusion Act. Because after 1882, they could not become, at least the parents could not become, citizens of the United States by birth or naturalization. That same year, Mr. Ark came back to the United States, and the customs people questioned his citizenship and let him back in the United States. In 1894, he left for China again. He was 21, and he married in China, and he returned to the United States in 1895 without his wife, and he was denied entry. The officials decided he was not a citizen. So the case reached the United States Supreme Court, and they had to decide whether he was a citizen by birth. And I'm going to read you very briefly the decision here and sort of explain it. Quoting them, the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications of children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within, and during a hostile occupation of part of our territory, and with a single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. Now this is very important, because they're saying that there's exceptions to the 14th Amendment. The first exception would be children of foreign sovereigns, meaning ambassadors, or children of enemies within a hostile occupation, and also children of Native Americans. You have to remember, I'm not going to spend too much time on this, but Native Americans were not granted citizenship until 1924. Now, one could argue that this was not appropriate at the time, but it existed. In other words, this first part of this decision creates exceptions to an absolute belief in automatic citizenship by being born in the United States. They went on, you have to understand, at that time there was no issue of illegal aliens in the United States, or people coming here temporarily on visas. It didn't exist. Furthermore, quoting the court, a child born in the United States of parents of Chinese descent, who at the time of his birth are subjects of the Emperor of China, but have a permanent domicile and residence in the United States, and are there carrying on business, and are not employed in any diplomatic or official capacity under the Emperor of China, becomes at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution, quoting, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So, just to give you my legal opinion as an attorney, subject to the jurisdiction thereof means that if you're an illegal alien, you're not subject to the U.S. jurisdiction. And in the Supreme Court, they're going to say this. And also, what's important about this case is it says here that they were permanently domiciled and residents of the United States. They were carrying on business here. And I will reach the conclusion, and the Supremes will reach the conclusion, that the parents of Mr. Ark were legal residents of the United States and not illegal aliens. Again, it's very important to understand that illegal aliens, or people on temporary visas, didn't exist at the time of the 14th Amendment or in 1898, the time of the Ark decision. Now, why do I think the Supreme Court is going to put a limitation on birthright citizenship? And that goes, I think, to a recent Supreme Court case written by Justice Kavanaugh, Noem versus Vasquez Perdomo. This was September 8th, 2025. And this involved the actions of Customs and Border individuals, employees of the government, questioning people about their citizenship under a federal statute. And the Supreme Court said they absolutely can do this. They've always done this. And there's an interesting paragraph in there written by Justice Kavanaugh, and this was a 6-3 decision, by the way, the 5 originalists as well as the Chief Justice Roberts. And I'll read this to you. So it is in this case, particularly given the millions of individuals illegally in the United States, the myriad significant economic and social problems caused by illegal immigration. The Supremes are taking a position there's definitely a problem with illegal immigration in the United States. They further mentioned the fact that it's estimated that there's 14 million illegal people in the United States. Some have even said close to 20 million. So I think the Supreme Court is definitely going to put a limitation on birthright citizenship. They've even mentioned in this Noem case that there's 2 million illegal immigrants alone in the Los Angeles area. You have to understand the way the Supreme Court considers cases and makes decisions. They don't operate in a vacuum. They're going to look at the social climate. For example, they're ruling on same-sex marriage. They're ruling on abortion. And most importantly, the issue in the recent presidential election and the importance of the fact concerning the border and all the number of illegal immigrants coming into the United States. In fact, Justice Kavanaugh mentions the fact that this has created social and economic problems for the United States. We have a $37 trillion deficit. So what's going to happen? In my opinion, the Supreme Court, based on their original interpretation of the 14th Amendment, they're going to look at the 14th Amendment and say it simply applies to those individuals who were in servitude, slavery, and it gave them citizenship. And then they're going to look at the Ark case and say, yeah, he was entitled to being have citizenship at birth because his parents were lawfully in the United States and had spent a lot of time in the United States, and his parents were not illegal immigrants. And more importantly, the Supreme Court mentions that you can put limitations on birthright citizenship. For example, the children of foreign diplomats. And we go back to that clause, subject to the jurisdiction thereof. And the Supremes are going to argue that subject to the jurisdiction thereof means that if you are here illegally, you're not subject to our jurisdiction. You're a citizen of a foreign country. If you're here temporarily on a visa, you're not subject to our jurisdiction. You are a citizen of a foreign country and you're just here temporarily. And you're not to be, your children that are born here are not to become citizens of the United States. Again, no European country has birthright citizenship. So it's my opinion that they're going to limit birthright citizenship. And some people are going to be unhappy. Now, are they going to take it from the date of executive order, January 20th? Are they going to take it from the date of when they reach the decision, which I think will be June 30th, 2026? Or they could not have any date included, which means that anyone, any child born in the United States, that their parent was not a citizen and they were here illegally or they were here temporarily, they cannot become a citizen of the United States. So another result I see from the fact that they're going to limit birthright citizenship is that what's going to happen is, if they decide the case the way I think they will, that there's going to be a lot of self-deportations. You have to also remember that there are significant numbers of women, some from very wealthy countries, that come into the United States, they're pregnant, and their sole purpose of being here is to have a child, so the child gets citizenship. And then if they get citizenship, some future date, the parents and family members can come into the United States. We call that chain migration. So just going back very briefly, this concept of chain migration, a lot of people don't like the term. So if the child of illegal parents, if she's born in the United States, where they're here temporarily, and the child becomes a citizen at some future time, well, they can stay in the United States, and then it's much easier for them to bring over their parents and their family members. So I think as a result of this decision, which I anticipate, there's going to be a great deal of deportations. So I want to remind everyone, this podcast is from Conversations with Dr. S, the Legend, and there's my email on here. And as some of you may notice, I like the old rodeo, and these are paintings done by a very famous artist, and I'm going to put the artist's name up here so that you can view other paintings by the artist, and if you like rodeo paintings. So this is Dr. S, the Legend, and welcome to the rodeo.